Thank you, Mr. Chairman. Yesterday, Congresswoman Maloney and I reintroduced the Financial Institutions Examination Fairness and Reform Act. I am very excited to be working with Ms. Mahoney, as she and I have worked together, and she has worked tirelessly to help the community banks. To me, this bill addresses the major concerns my community banks have had with the regulators during the financial crisis. The core purpose of this bill is to provide financial institutions a way to appeal examination determinations to a neutral and independent third party. This independent examination review director is tasked with determining whether examiners have fairly and accurately applied rules and guidance from the regulators. All too often, I have heard that banks in my community have nowhere to turn when an examiner makes a mistake or is applying rules unjustly. I would like for each of the Federal supervisors just to go down, simple yes or no answer. Will you support or remain neutral on this bill? Just a simple yes or no.
No, sir. Our agency doesn't have a position on it, so I'm not in a position to say we'd support or not.
Representative Westmoreland, we don't support it, no.
We have concerns with various aspects of the examination fairness bill.
Mr. Stillman, do you have anything to say? Do you know anything about it?
No, sir.
All right, good. Ms. Eberly, you brought up a point about when my colleague from Georgia, Mr. Scott, and I, who have been working tirelessly on our failure of community banks, mentioned the acquisition, development, and construction loans. It brings up why I think this bill that we have is so important, because it talks about non-accrual and placing loans in non-accrual. I was in the building business. I was in the development business. I was in the real estate business. I know for a fact of some of these loans that were current, they have been going by and abiding by all the terms of the loan, but they were forced to be put into non-accrual, which took the cash position of these banks down. Now, what is wrong with a small community bank being able to say, look, I know this guy, he's paid his loans, he's had his loans. Why does he have to go into the non-accrual status?
After the crisis of the late 80s and early 90s, Congress passed a law indicating that the financial institution regulators had to require institutions to follow GAAP, generally accepted accounting principles. So we don't have that flexibility.
Well, we're trying to, and that's why we're trying to change the law.
Right.
But you don't want us to change the law.
Well, a couple of problems with the idea of an ombudsman that would overturn agency findings without having accountability for the supervision of an institution.
So basically, the government agencies think you know more about a bank's borrowers than what they do. Is that correct?
No, sir. We require institutions to follow GAAP.
Okay.
And if they weren't following GAAP, they'd essentially have two sets of books. So
okay.
One set of books where they reflected it that way, and one for the regulators.
And I'm sorry you all opposed the bill. Also wanted to talk about the Economic Growth and Regulatory Paperwork Reduction Act. In the past 15 years, there's been 801 regulatory rules that have gone in to these banks. My concern is the volume and the complexity of these banking regulations is going to put more of our community banks out of business. And since Dodd-Frank, my understanding is that those rules will not be included in this next review. And so it will be, I think, 2026 before these Dodd-Frank's rules will be considered under this rule. Can you tell me why Dodd-Frank rules aren't being considered in this next review? And can anybody tell me, after 801 regulations, can you tell me how many has been, because this was only up to 2006, how many have been after 2006, and what paperwork has been reduced or what rules have been removed?
Representative Westmoreland, I'll take the first part.
Sure.
And we had issued, the regulatory agencies had issued a letter that indicates that we will include all regulations that have been implemented in the AGRIPA process going forward. So, starting with our next hearing in Boston in May, but also the public comment period. So we did decide to include all rules. So that would include the Dodd-Frank rules that have been implemented would be part of the AGRIPA process.
The time of the gentleman has expired, but I would ask the other witnesses to respond to the gentleman's question as well. Now go to the gentleman from Kentucky.